Thinking of driving with an open bottle of alcohol in your car? Do not keep it in the front or anywhere near you. It is a crime to have an open bottle of alcohol in your car, and you can get charged with an open container violation or worse, a DUI. The best spot to put it is in your trunk, so you won't have access to it while you're driving. Why you can't cheat a DUI test? Because you don't know what the police are looking for when they perform that. When they perform the eye test, they're not checking to see whether or not you can follow the pen with your eyes. What they're actually doing is checking your eyes for involuntary eye movements you make when you're impaired. And this is called nystagmus. Officers can determine your impairment level based off your eye movement alone. When you're following the pen, thinking you're doing a good job, you're probably not. I bet you don't know this about DUI stops. Unlike your breath sample, you are not required to perform field sobriety exercises like walking in a straight line. So should you? The harsh truth is, if the officer is already asking you to perform these, he most likely has enough evidence to arrest you for DUI. So all you're really doing is building a case against yourself. That's not to say that if you perform well, the officer won't let you go. If you do refuse, always be respectful. You don't want to escalate the situation. The best way to avoid this is by calling an Uber or Lyft. Should you blow in a breathalyzer if you get pulled over for a DUI? The police officer asks you to blow in a breathalyzer means he already has enough evidence to arrest you for a DUI. If you blow, it will be used against you to prove you were impaired. In Florida, if you blow above a .08, you will get arrested and it will be almost impossible to prove that you were not intoxicated. If you refuse to blow, the prosecutor is going to argue you did this because you know you would blow over the legal limit. Know your state's legal limit and drive smart, and follow me for more DUI tips. What to do if you've wrongfully been arrested for a DUI. If you're not impaired, blow into the breathalyzer so you can prove it. If the police ask for a urine sample, give it, because if you don't, the police and prosecution will argue that you were impaired by another drug, and that's why you refuse to provide a sample. Then take a drug test from an independent lab. Over-the-counter ones do not work. And contact an attorney as soon as possible to help you defend your case, and follow for more DUI tips. Can you get a DUI off your own prescription medicine? A DUI isn't just for drinking and driving. It applies to any substance that can get you intoxicated. It does not matter if you have a prescription for it or are required to take it by a doctor. If your medicine makes you impaired or affects your driving, you can still be charged and arrested for a DUI. Make sure you check your labels and follow for more legal tips. Will you go to jail if you get arrested for a DUI? Every county and case is different, but if it's your first DUI, besides spending the night in the sober tank, you probably won't get any jail time. Legally, they can't release you if you're still impaired. Subsequent DUIs typically do carry some jail time. If it's your second DUI within 5 years, there is mandatory jail time. And if it's your third DUI, it can be charged as a felony. Even without jail, Florida has a mandatory driver's license suspension, 6 months probation, thousands of dollars in fines and court costs, community service hours, and more. First-time offenders, though, may be eligible to take certain programs that will allow them to reduce the charges if everything gets completed. You should never drink and drive, but you should follow me to learn how to avoid DUI.